Ready?
Yes.
Recording in progress.
All right, good morning. Are you Johnny Richards, appearing from the jail?
Yes, sir.
Okay, this is case number 21, CR 180. State of Ohio versus Johnny Richards. This hearing being conducted on Zoom. As indicated, Mr. Richards is appearing from the jail. His attorney, Kathy Packner, is appearing from her office, and appearing on behalf of the state is Assistant Prosecutor King from his office. Ms. Hackner, you and your client both agreed to have this matter conducted remotely by Zoom rather than having an in-person appearance in court.
Yes, we do, Your Honor.
And you're in agreement with that, Mr. Richards?
Yes, sir.
Right. Now, Mr. Richards, since we're not in the courtroom and you're not sitting next to or close to your attorney, if you need to talk with her at any time during this proceeding, just tell me, and I can put you and her in what's called a breakout room, where the two of you will be able to talk privately. No one else will be able to see you or hear you. Okay? Thank you. All right. Now, Mr. Richards is charged with breaking and entering and theft, both fifth-degree felonies. This matter was originally set for trial, I believe, tomorrow, and it had been continued at pre-trial last week due to circumstances involving the court schedule. And the court was then informed that parties had reached an agreement, and the matter was set for a hearing this morning. And Mr. Richards, I've been presented with a 3-page form which indicates that you are going to withdraw your not guilty plea, plead guilty to the first count, actually to both counts of the indictment. Now this, I'll hold this up to you, to the camera so you can see it. And you see there your name and case number and plea guilty form there on the first page of this document.
Yes, sir.
And then on page 3, there are signature lines. And about a third of the way down, there's a sentence that reads, "I enter this plea voluntarily." Immediately below that, there's a signature line with the signature defendant printed below. And I'll hold that up to the screen, and is that your signature in that line? All right. When did you sign this agreement, Mr. Richards?
Last Thursday.
It was last Thursday.
All right. And you were at the jail with your attorney when you signed it?
Yes, sir.
And did she go over with you and explain everything to you so you understood what it was?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel that you've been rushed or pressured in any way into doing this?
No, sir.
And are you entering into this agreement to plead guilty, in this case, voluntarily?
Yes, sir.
All right, the agreement states on page 1 that you're going to withdraw your not guilty pleas, plead guilty to counts 1 and 2. Count 1 being breaking and entering under section 2911.13b, the higher revised code of fifth-degree felony. Count 2 being theft under section 2913.02a1 of the higher revised code of fifth-degree felony. Both of those charges having a potential maximum prison term if convicted of 12 months. There's a minimum of 6 on each count. There's a fine payable of up to $2,500 in each count. You understand that?
Yes, sir.
Now, in the event that you are convicted of both of these offenses, and in the event that you're sentenced to prison for both offenses, upon completion of that sentence, if you are convicted of both, the court could order those sentences to be served consecutively to each other. So that means it'd be a total maximum of 24 months available and a total fine of $5,000. Do you understand that?
Yes, sir.
And are you facing any penalty charges anywhere else, Mr. Richards?
No, sir.
Are you currently on probation, community control, post-release control, or parole for a felony?
Probably.
Okay, what is the charge down there?
Another felony.
Oh, excuse me. Have you been convicted of that, or is that charge is pending?
Yes, been convicted.
Okay, so you're currently on community control down there.
Yes, sir.
All right. Well, under the law, if you are convicted of these offenses, then most likely, depending on when they were alleged to be convicted, that it's possible, I'll put it that way, it's possible that that could be a violation of your terms of your community control in that county. In which case, they could revoke your community control, even if you got it not community control here, and sentence you to prison. You understand that?
Yes, sir.
Now, in the event that you should be sentenced to prison in both Brown County and Lahaina County, it is possible that those sentences could be ordered to be served consecutively, meaning one after the other. So that means it would be a total possible 24 months in this county And you said it's a felony 5 down in Brown County, so there'd be another 12 months possible there, for a total of 36 months. You understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for these offenses. I can impose what's called community control or non-prison sanction. And what that means is instead of going to prison, you would be put under the supervision of a probation officer under the term set by the court. And if during that period of time the probation department felt that you were not in compliance with the conditions, they would have to file a written notice of that with the court, serve a copy on you. You would be entitled to have a hearing, and if the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control, and then sentence you to 24 months and fine you $5,000. Do you understand that?
Yes, sir.
Now, in the event that you should be sentenced to prison, either directly or if you have your community control, be put on community control after revoked, if you are sentenced to prison, then upon completion of that prison term, the law provides that the adult parole authority has the option, if they choose to use it, to put you under what's called post-release control supervision for a period of up to 2 years. That means that you'd be supervised by a parole officer the terms they set because the judge has nothing to do with that. And if during that period of time they determine that you had failed to comply, then they can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for one violation, but there is a cap of half of whatever prison term is served for one or more violations. However, if you are convicted of a felony on post-release control supervision, then in addition to whatever sentence the judge in the new case would impose upon you, that judge would also sentence you in this case to an additional period of 1 year, or whatever time might be left on that period for post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, the charges in this case read as follows. On or about June 25, 2021 in Highland County, Ohio, that Michael T. Orr and you did knowingly by force, stealth, or deception trespass on the land or premises of Gerald Doug Howkey for purpose to commit a theft felony in violation of section 2911.13b of the Ohio Revised Code. So that's the charge of breaking and entering. And then count 2 alleges on or about the same date, County Mr. Orr and you did with purpose to deprive Gerald Doug Howkey of his property, knowingly obtain or exert control over it, with Milwaukee saws, Milwaukee impact, Milwaukee batteries and chargers, Milwaukee sawzall with blades, Milwaukee metal shear attachments, steel chainsaws, and other miscellaneous items without the consent of Gerald Doug Howkey, the owner person authorized to give consent. Said property being valued at equal to or greater than $1,000 or less than $7,500 in violation of section 2913.02A1. So that's the charge of theft. Both of those are 5th-degree felonies carrying possible prison term between 6 and 12 months. Fine of $2,500 as I indicated. Now, Mr. Richard, do you understand what you've been charged with by the state, what they said you did, when, where, and how they alleged you did it in each case? And you understand the possible penalties for each offense?
Yes, sir.
Now, have you discussed the nature of these charges, the evidence of the case, possible legal issues of the case, possible defenses you might try to raise at trial, the possible outcomes of the trial with your attorney?
Yes, sir.
Are you satisfied with your advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
Yes, sir.
Now, the agreement states on page 2, there's 3 lines that are typed in bold print and underlined that read as follows. Defendant shall enter plead guilty to the indictment. State defense jointly recommend community control and the defendant be referred to the drug court. Defendant agrees to make full restitution. Defendant agrees to cooperate fully against co-defendant. That's your understanding of the agreement.
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
Yes, sir.
Under the law, Mr. Richards, the matter of sentence is up to the judge, not to the parties. And so, even though there's an agreement that you should get community control, if you plead guilty, the court is not obligated to follow that recommendation. I could, after I've reviewed all the evidence, decide that that's not the appropriate sentence and sentence you to a term of between 6 months and 24 months and fine you with $5,000. You understand that?
Yes, sir.
And do we have a figure on restitution, counsel?
I do not yet, Your Honor. We're working with the victim to try to figure out the amount, but I don't have a figure at this time.
All right, well, we'll need to have that at the sentencing hearing then.
Yes, sir.
All right. Now, Mr. Richards, do you hold any kind of a license or certification from a state agency that governs or regulates any kind of profession?
No, sir.
Now, under the Constitution, you have certain rights you must understand before I can accept your plea. First, you have the right to have an attorney after it's appointed to represent you, not simply work the case out, but to provide whatever sentence might be available to you under the law that you wish to provide. So, if you decide you don't want to do this, that you'd rather defend against the charge, you'll still be represented by Ms. Hapner. She'll defend you, including having a trial if that's what you want. You understand that?
Yes, sir.
All right, now under the Constitution, Mr. Richards, you have the right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, and then they would decide by unanimous verdict, meaning after the instruction of the law, that is, they would decide by unanimous verdict, meaning all 12 have to agree, as to whether or not the state proved your guilt on either or both charges. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up in writing the right to have a jury trial. In that case, you would have what's called a quarter bench trial, which means that instead of a jury hearing the evidence, the judge will hear the evidence, the judge will apply the law, the judge will decide whether or not the state proved your guilt by proving beyond a reasonable doubt. Do you understand that?
Yes, sir.
All right, under the Constitution, you have a right to confront witnesses against you and cross-examine through your attorney. What that means is that witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right, now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So what that means is if you have witnesses you're not certain going to come in voluntarily, your request the court issues a court order as well as subpoena. That would force those people to come to court to be able to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that? I didn't hear you.
Yes, sir.
Okay. Now, under the Constitution, you have a right or a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, except in one situation, that is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent of these charges until proved guilty by the state of Ohio on every essential element of each offense by proof beyond reasonable doubt. So what that means is that the burden of proof isn't on you to try to prove that you're not guilty of these charges simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charged in each count, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now, Mr. Richards originally pled not guilty. Not guilty plea denied the allegations that he denied committed any crime. He didn't exercise or invoke all of the rights that I just described for him. Now, if you change your plea from not guilty to guilty on these two charges, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations that he died, admits that they're a crime, that you committed that crime. And that plea waives gives up all of the rights that I've just described for you here this morning, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilt, the waives gives up your right to have a jury or court trial. The waives gives up your right to confront the witnesses against you and cross-examine through your attorney. The waives gives up your right to use the power of the court to compel or force a witness to come to court to testify for you, just like the state. The waives gives up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. And the waives gives up your presumption of innocence because if you say you're guilty, then that's what's used to find you guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence or under certain circumstances you file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right, now, do you have any questions, Mr. Richard, about the charges or the possible penalties?
Can I speak with this happening for a second, please?
Sure. All right, did you get your questions answered, Mr.
Yes,
Richard?
sir.
Okay. All right. Now, you understand the possible penalties for the offenses.
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Again, you understand that the recommendation is not binding on the sentence, is not binding on the judge.
Yes, sir.
You have any questions about the constitutional rights of its claim?
No, sir.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here this morning?
No, sir.
You understand?
Yes, sir.
Anything else you need to speak to Ms. Hackner about before we go any further?
No, sir.
Do you have any questions about anything I've explained to you here today?
No, sir.
Then is it your decision, Mr. Richards, to withdraw your not guilty plea, plead guilty to both counts of the indictment pursuant to the terms of this written plea agreement that I've just gone over with you?
Yes, sir.
Right, as to count one, which alleges on or about June 25, 2021, in Highland County, Ohio, that Michael T. Orr and you did knowingly by force, stealth, or deception trespass on the land or premises of Gerald Doug Houke with purpose to commit a felony in violation of section 2911.13b of the Ohio Revised Code. They charge breaking and entering a fifth-degree felony, carrying possible prison term 26 to 12 months, and fine of $2,500. How do you plead?
Guilty.
Then as to count two, which alleges on or about June 25, 2021, in Highland County, Ohio, Mr. Orr and you did with purpose to deprive the owner, Gerald Doug Houke, of his property, knowingly obtained and exert control over said property to wit Milwaukee saws, Milwaukee impacts, Milwaukee batteries and chargers, Milwaukee sawzall with blades, Milwaukee metal shear attachments, steel chainsaws, and other miscellaneous items. Without the consent of Gerald Doug Houke, the owner person authorized to give consent, said property being valued at equal to or greater than $1,000 but less than $7,500, violation of section 2913.02A1, charge of theft, also a fifth degree felony, carry possible prison term 26 to 12 months, and fine of $2,500. How do you plead? court finds that on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver pursuant to criminal rule 11. The plea is accepted, and each count is accepted and ordered filed. Defendant is found guilty of both counts as set forth in the indictment. The defendant, a pre-sentence investigation is ordered, which shall include an assessment for substance use disorder treatment as well as mental health. Bond will be continued. Case is referred to the drug court. Sentencing hearing will be set for February 17 at 1 o'clock.
Your Honor, I'm due in Fayette County Juvenile Court at 1 o'clock that day.
Oh, okay. How about 11 a.m. then?
Yep, that works, that's fine, thank you.
All right, thank you. All right, so the probation department will be in touch with you. Are you being held on this charge or other charges?
But that's the main charges.
Okay, so the probation department will be getting in touch with you to do the pre-sentence interview as well as the drug court coordinator to do an assessment to see if you're qualified, and if so, if you're interested in applying for that program. That's not something the court orders. Court will allow people to apply and determine if they're suitable candidates for that as opposed to traditional community control. So they'll explain that to you. All right, anything further, counsel?
No, Your Honor.
All right, thank you.
Is it 11 o'clock goes in as well?
Okay, this is case number 21-CR-175. Dale Howe versus Michael Shane Riley. Attorney on behalf of the state, Assistant Prosecuting Attorney Advocate. Attorney on behalf of Lieutenant Attorney William Armentrout. And are you Michael Shane Riley?
Yes, sir.
Now, Mr. Riley is indicted for receiving stolen property of fourth-degree felony. This matter was set for a plea hearing this morning. The court has been presented Mr. Riley with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty to receiving stolen property, the charge in the indictment. On page 3, there are signature lines. There's a sentence about a third of the way down that says, I enter this plea voluntarily, and immediately below that, there's a signature line which looks like the signature appears to be the M. Riley. Is that how you sign your name?
Yes, sir.
Okay. And when did you sign this document, Mr. Riley?
This morning, Your Honor. And
And did you go over with your attorney before you signed it?
yes, Your Honor.
When you signed it, did you understand it was an agreement to plead guilty, which means it won't be a trial, and next step in your case will be a sentencing hearing?
Yes, Your Honor.
And did you have enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And when you
If
came,
I may interject for just a second, I've advised my client all along, we've been discussing this case for a couple of months now. I advised him that we'd not received an Adam agree with this, we'd not received any notice of restitution in the discovery, but I said it's very possible that there is restitution. Adam has just now handed it to me, and I guess all I'm saying, this isn't going to affect our deal, but we may want to separate hearing. The restitution amount, to me, seems a little large, but that might be for you to decide. The vehicle was recovered, or it's both a mule or a gator,
you,
Komodo, whatever you call
okay. Kubota, RTD 900. I have a thing. Fine. Okay. Now, when you came here today, Mr. Riley, was this something you were expecting was going to happen?
Yes, Your Honor.
Did you been talking to your attorney about the possibility of doing this? So you're not taken aback or surprised or anything by this?
Also, surprised by the restitution.
Other than that, yeah, and that'll have to be decided at a hearing. If you plead guilty and there's not an agreement on restitution, then it would have to be set. It would be a hearing in which they'll have to present evidence, and you'd have a right to contest that if it comes to that. If you decide that you think it's too long. Okay?
Yes, Your Honor.
All right. So, you feel that you've been rushed or pressured in any way into doing this today?
No, Your Honor.
Are you entering into this agreement to plead guilty voluntarily?
Yes, Your Honor.
Right now, the agreement states that you are going to withdraw your not guilty plea, plead guilty to the charge of the indictment of receiving stolen property, a fourth-degree felony under section 13.51. Further states you understand that the possible penalty for that could be a maximum of up to 18 months in prison. The minimum would be 6 months. There would be a fine payable of up to $5,000. You understand that?
Yes, Your
Are you facing any felony charges anywhere else, Mr. Riley? Are you currently on probation, community control, parole, post-release control for felony? Now, under the law, if you should ever be sentenced to prison for this offense and serve a prison term, once you complete that term, the law provides that the adult parole authority could choose to put you in what's called post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised on the terms that they set. And if during that period of time they determine that you failed to comply, then they could return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for any one violation. But there would be a cap of your prison term for all violations. However, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in that new felony case would impose upon you, that judge would also be authorized under the law to sentence you to an additional period for committing that offense while under post-release control in this case, 1 year or whatever time is left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that? Right now, under the law, not required to send you to prison for this offense. You can impose what's called community control, which means that instead of being sent to prison, you would be put under the supervision of a probation officer in the term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not compliant, they would file a written notification of that in the court, provide you a copy, and then there would be a hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 18 months and fine you $2,500. You understand that?
Yes, sir.
Now, the charge in this case alleges that on or about August 8, 2021 in Highland County, Ohio, you did receive, retain, or dispose of certain property being in 2017 Kubota RTV 900, property of another Stephen Williams, and that you knew or had reasonable cause to believe that obtained through the commission of theft offense, the property was being valued at equal to or greater than $7,500, but less than $37,500. In violation of section 2913.51 of the Ohio Revised Code. So that would be the charge of receiving stolen property for your penalties I just mentioned. Now, do you understand what it is you've been charged with, what the state said you did, when, where, how, alleged you did it?
Yes, sir.
You discussed the nature of the charge, possible evidence of the case, possible legal issues of the case, possible defenses. You might try to raise a trial, and possible outcomes of the trial with your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time? Are you taking any prescription drugs?
Yes, sir.
Yes?
Yes, sir.
And what are you taking it for?
I just take like ibuprofen and gabapentin and stuff.
Okay, but,
That's what I'm on.
All right. Nothing that affects your mind or your ability to understand or to comprehend what's going on. Okay. Now, have any threats been made to make you plead guilty?
Okay.
Now, on page 2, there are a couple of lines that are printed in bold and underlined and read as follows. Defendant shall enter plead guilty to the indictment. State defense jointly recommend community control. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes, sir.
And again, the matter of restitution will remain to be decided by the court if there's not an agreement. You understand that?
Yes, sir.
Now, other than that, has anyone promised you anything? Under the law, Mr. Riley, the matter of sentence is up to the judge, not to the parties. So even though there's an agreement between the parties that you should get community control or probation if you plead guilty, the judge is not bound by that. So if you plead guilty, I don't have to follow that recommendation. I could decide that you should be sentenced to a term of imprisonment between 6 and 18 months and fine $5,000. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental body that regulates any kind of a profession?
Okay.
And you have certain constitutional rights. You must understand, Mr. Riley, before I can accept your plea, first you have a right to have an attorney. Mr. Armstrong has been appointed to represent you, not simply to work the case out, but to decide or to provide whatever defense could be available to you in the law that you would like to provide. So if you decide you don't want to do this, that you want to fight this charge, Mr. Armstrong will continue to represent you, including trial, if you want that. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to a jury trial in this matter, Mr. Riley, in which 12 people will be selected, a group of citizens that were summoned, that live in this county, that are summoned for jury duty on your trial date. After they were selected, the evidence would be presented, they'd be instructed on the law, and they would decide by unanimous verdict, 12 and a half degree, on whether or not to say proof guilt or proof guilty for that. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means you give up your right to have a jury trial. In that case, you would have what's called a court of bench trial, meaning instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not to state proof guilt or proof guilty for that. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine through your attorney in open court. What that means is that the witnesses would have to come into court and testify in a public setting in front of you, your attorney, and anyone else who's present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence to help your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination. I'm sorry, no. You have a right to use the power of the court to compel a forced witness to come into court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, your request, court issues a court order, called subpoena. That would force those people to come to court and be available to testify if they wanted them to, even though they don't want to be here. This is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you're not forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except in one situation, which is if there's a jury trial. You don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent until proven guilty of this offense by proof beyond a reasonable doubt and every essential element of the offense charged by the state of Ohio. What that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is on the state to prove that you are. In fact, under the law, you're not required to present any evidence at all at your trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt in every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally, you entered a plea of not guilty. The not guilty plea denied the allegations in the indictment, denied you committed any crime. That plea exercised will invoke all of the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea would waive or give up all the rights that I've just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead, but with that exception, your plea of guilty would waive or give up the right to have a jury or court trial. You waive or give up your right to confront witnesses against you in open court and cross-examine them through your attorney. You waive or give up your right to use the power of the court to compel or force witnesses to come to court and testify for you, just like the state. You would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you define as guilty. And finally, you would waive or give up your right to require the state to prove your guilt by proof beyond a reasonable doubt in every essential element of the offense charged. But again, legally, they're not required to prove it. It also waives or gives up your right to file an appeal of any alleged violations of your rights that you think may have occurred up to this point. And a plea of guilty does subject you to being sentenced immediately by the court if it's decision of the court. Do you understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right, Mr. Riley, you have any questions about the charge and the possible penalties?
There you go.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
There you go.
Understand it?
Yes, sir.
Have any questions about the constitutional rights I've explained?
There you go.
Understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
There you
You understand?
go. Yes, sir.
Is there anything else you'd like to speak with your attorney about before we go further?
There you go.
You have any questions about anything that I've explained to you today? Then is it your decision to withdraw your not guilty plea guilty to the charge and the indictment of receiving stolen property pursuant to the terms we disagreed with this conduct?
Yes, sir.
Okay, then as to the charge, which alleges that on or about August 8, 2021, in Highland County, Ohio, you did receive, obtain, or dispose of certain property being a 2017 Kubota RTV 900, property of another, Stephen Williams, said Michael Shane Riley, knowing or having reasonable cause, believes that property had been obtained through the commission of theft offense, said property being valued at equal to or greater than $7,500, less than $37,500. The violation of section 2913.51 of the Ohio Vice Code, the charge received stolen property, fourth degree felony, carrying possible prison term of 26 to 18 months, fine of $5,000 out of the plea.
Guilty, Your Honor.
Thank you. You can see it. Court finds that in this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Rule 11. Please accept that order. While the defendant is found guilty of receiving stolen property as charged, the court will order a pre-sentence investigation, the same bond. So you can report to the probation department immediately after court today to set up your appointment for the pre-sentence interview. And we'll set the sentencing hearing for March the 2nd at 9 a.m. So you get your assignment notice for that, and then go down to the probation department immediately after you leave work. Anything further, council?
Mayor,
No, yeah.
All right, thank you.
Thank you, Lord.
Waiting on Mr. King to sign on.
I don't think he was gonna do this, Judge. I think Annika was gonna do it.
Or Annika, okay, yeah. Follow there, somebody's supposed to be signing.
Annika said she's on there.
Well, she's not. She must be on the wrong one. Oh, it's a 10:30, or the 9:30 one, was the first one, it was a 10:30 one.
Okay.
This is 11 o'clock.
Yeah, no, I mean, it's the same invitation. We started at 10:30. Here she goes.
Okay.
Okay, this is case number, is 09-CR-169. And also there's a number of other, cases. Actually, I think Mr. Armstrong, this is, normally filed as a, when there's multiple cases, it's normally filed as a civil action, but, we'll go ahead, I mean, it's not a problem as far as I'm concerned. So it's 09-CR-169 et al. And I'll recite those in a moment. State of Ohio versus Alan Elmore. Mr. Elmore petitioned for application for relief from disability from weapons. You are Alan Elmore, hearing on the
Yes.
And this hearing is being conducted by Zoom. His attorney is William Armentrout, appearing from his office. Prosecuting Attorney Collins is appearing from her office. This application was filed on November November 22nd. And recited in there are request relief from disability from trafficking drugs, 1980, case number uncertain. Case number 02-CR-229, 03-CR-85, 09-CR-45. This case, 09-CR-169, 83-CR-78, 84-CR-12, 85-CR-116, and 84-117. All right, Mr. Armentrout.
Never asked the court to consider granting a motion. I think it's almost exactly, a little more than 4 years ago, Alan asked to have a disability relief, and it was denied by the motion. I believe the court felt at that time not enough time to do an action. That's one of the reasons, along with his record. We filed 2 years ago, and again, the court believed that maybe not enough time had gone by, or there was no specific time requirement. So we renewed the motion there. It's been two years, like 2 years plus, I think. Hopefully the court had a chance to review the letter. I just brought it over today from Mr. Steve Dillon, who Alan, I think, works with and attends church with. The court is very familiar with Alan's lengthy record, because I think he probably prosecuted every one of those cases. Maybe not the last one, I'm not sure. But by all appearances, Alan, how old are you now, Alan? 64? 63. 63. You know, it's still day-to-day judgment. You hope that he's turned himself around. He seems to be very busy. He does his own whole kind of maintenance job. He's done work for me personally here 3 or 4 months ago. Was very satisfied with that. And his primary interest is he'd like to be able to go hunting more. So, and Alan may answer questions for you or have something to say. We'd ask the court to consider his ability to listen.
All right, Mr. Elmore, anything you'd like to say?
You know, I made a lot of bad choices in my life, and it carried on through my life, and then I started making the right choices in 2009, and, you know, I've been going to church and everything, just been trying to live the right kind of life, you know. I was getting too old to do all that other crazy stuff. It's just, it don't pay. You know, I've got a good life now. And I've got good friends at Perfect Church, and I just like to go hunting with them, enjoy life with them a little bit.
Okay, I was looking through the file here. I know that your judicial release was granted, I believe, on August the 6th, 2014, but there's not a copy of it in this case. It must be in the 045 case. When did you get off of your community control, Mr. Elmore?
Pardon?
Do you know when you were released from probation from your judicial release?
From this time, it was about a year after I got out.
All right, so probably a year and a half. Usually I go a year and a half. So August the 6th would have been when I granted it. Let's see, I can't recall. It's not. Did you go to STAR or did you go into some treatment facility when you were granted judicial release?
No, you released me judicial release, and
Okay.
I went out to FRS, and
okay.
all they had for just a little bit, and I completed that and everything, and
Okay. So probably around February of 16 is probably March or February of 16 is probably when it was released. Because I usually go a year and a half minimum. I've set it at 3, and depending on the recommendation of probation, it's terminated earlier. But I think what's happened is the entry is in the 09 CR 45 case and not in this one. So we'll have to find out. So. All right. Anything else you'd like to say, Mr. Elmore?
No, I think that's it, Your Honor.
All right, Mrs. Collins, on behalf of the state, do you have anything you would like to say?
The state has no position on this, Your Honor.
All right. Well, Mr. Elmore, you know, you've had a really long criminal history, and as Mr. Armentrout mentioned, I was a prosecutor in all but your last couple of, anything prior to 2000 I was a prosecutor on, anything after 2001 I wasn't, including these most recent cases. But I will have to say that it does appear that you have finally changed a lifetime of bad behavior. And, you know, mentioning bad decisions is kind of an understatement because you're involved in some pretty bad stuff over a period of time. And, I know one of them involved weapons, carrying a weapon into a bar, and you were convicted of that. But it does appear that you have turned your life around, that you've led a law-abiding life now for, since 2014, when you were granted judicial release. And it appears that you're working, and you're going to church, you're around the right kind of people, and hopefully, like you said, with your age, you realize that your body can't tolerate this. In fact, you probably already realize that. So notwithstanding the extensive records you have, I'm going to find that all of your convictions have been discharged from either sentence or supervision, that you let a law-abiding release since that time, and actually before that time, and I know in 2014 when I granted judicial release, even before that, when you came in front of me for sentencing, you had implemented some changes, but at that time I discovered your criminal history was such that you couldn't be allowed to not pay the price for those. But the good thing is I sent you to prison, then let you out, that didn't interfere with your changes. So, as far as Ohio law is concerned, there's no other bars other than, to your owning or having guns, other than those that were listed in your application. So the court is going to grant your motion and restores you to the civil rights regarding firearms that any other person has. I will tell you that it is subject to certain conditions set forth in paragraph F, 29, 23, 14, and that is, it only applies to those indictments and convictions that were referenced in this court. So if you have any anywhere else, it doesn't affect those. The weapons must be, or firearms must be lawfully acquired, possessed, carried, or used. The court could, for good cause shown, and notice after notice, revoke this if the state feels that there and proves to the court that there's good cause for that in the future. It's also void automatically if you should commit any offense set forth as far as illegal possession or carrying of firearms, or if you commit any further offenses involving firearms. So other than that, you are fully restored, and as soon as that entry goes on, you get a certified copy of that and be able to show that if your record pops up in any future firearms acquisitions for licensing. And you're to pay the court cost of this proceeding. I think you paid all your court costs in these two cases, didn't you?
I did, yeah.
Okay. All right. Is there anything further from council?
Yeah.
Thank you. I believe our 11:30 is going to be in person. Yeah, I think, or did you say? Okay, this is case number 210179, State of Ohio versus Michael T. Orr. Representing the state is Assistant Prosecutor Attorney Matt King, representing defendant Attorney Nick Wagner, and are you Michael T. Orr?
Yes, sir.
All right, this matter was set for hearing today on an application for, on a motion for intervention in lieu of conviction. And I was just checking and found out that actually there wasn't a report done, but probation said they did find a felony conviction. And I was told by bailiff that you're not going to go forward on that. He didn't feel he was eligible, so I really good.
If I may, sir, I guess I'm thinking out loud, and I apologize to the state, I guess I never thought, I just came across this last week, even with the prior, I think under the new statute, you're still eligible with a prior felony, am I correct, Your Honor?
Legally,
Yeah, so I guess it'd be up to Mr. King.
but I can tell you that my history is such that I don't think I granted any.
And I apologize, I don't want to jerk the rug every time.
Nonetheless, he didn't report for invest. Oh, well, I shouldn't say that. He didn't go down and talk to them, and they didn't get the info. So there is no report, so I can't do an intervention at this point. There's nothing to go on. Now, if you want to go ahead and have that done, then that's fine. We can we'll go ahead and go through that process if you want to.
If I go over around the curve.
Sure. Sure.
In my client, when we first met, this was the path he anticipated. And I only brought that up because I was in another county. They said, and it clicked, you're still eligible under the statute. I'm just Michigan, I won't try to pull it on me. Right. But we want to go forward today with the community control recommendation.
So you want to go forward with the plea, guilty, and withdraw your motion for intervention?
Yes, sir.
Okay. All right, and just for the record, there was a co-defendant here this morning who did plead guilty, and so when I saw this as an intervention, I was wondering about, even that issue, because I don't know his eligibility, but certainly with the prior conviction, I would be highly unlikely to grant a motion.
Yes, sir.
So just so that that's out there, so that you understand that. So, but you do understand if you want to go forward on that motion, we can go ahead and postpone this, get a report, come back, evidence be presented, and then I make my ruling if you want to do that, Mr. Morgan.
No, I'm good.
You agree to withdraw the motion
Yes, sir.
for intervention? Okay. All right, thank you. All right. Well, the defendant is charged in a 2-count indictment of breaking and entering into theft of 53 felonies. And I have now before me, had at the beginning of the hearing, the plea of guilty form that Mr. Wagner referred to. And this is a 3-page form that's prepared by the prosecutor's office from their computer. And on page 3, there are signature lines. And about just almost halfway down, there's a sentence that says, I enter this plea voluntarily. Immediately below that, there's a line of the signature defendant. And it says Michael Orr. Now, did you sign this agreement that I'm looking at?
Yes, sir.
When did you sign it?
Just a little bit ago.
Okay. So you went over this with your attorney before you signed it?
Yes, sir.
You understood that it's an agreement to plead guilty, which means it won't be a trial. The next step in your case would be a sentencing hearing.
Yes, sir.
And there wouldn't be any consideration for intervention in lieu of conviction.
Yep.
Now, have you had enough time to fully consider this matter before making this decision?
Yes, sir.
And do you feel that you've been rushed or pressured in any way into doing this?
No, sir.
Are you entering into this agreement to plead guilty in this plea agreement voluntarily?
Yes, sir.
All right, the agreement states on page 1, you're going to withdraw your not guilty plea, plead guilty to both counts, breaking and entering under 2911.13b, the Ohio Vice Code 53 felony, and count 2 theft under 2913.02a1 of 53 felony. Further states that you understand that the maximum prison term for each of those offenses of convicted could be 12 months, The minimum is 6 months if a prison term is imposed. There's a fine available of $2,500. If prison is imposed, and if fines are imposed, it could be ordered to be consecutive, meaning that you could face a maximum prison time of 24 months and a maximum fine of $5,000. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
Yeah, I got indicted for previous charges in Claremont County.
Okay, what are those charges?
It was identity theft and,
Took the license plate and he gave it.
Okay.
Allegedly,
I understand, okay.
gave a fake name when he got pulled.
So, in the event that you were be convicted in that county and sentenced to prison, and also sentenced to prison in this county, those sentences would be ordered to be served consecutively, meaning one after the other. You understand that?
yes, sir.
Are you facing any, or are you currently on probation, community control, parole, or post-release control for a felony in any jurisdiction?
Just got put on probation in, Claremont,
For that charge?
reporting bond or whatever.
Pardon me?
Like a pretrial supervision.
Oh, pretrial supervision, not convicted yet, but just like you were here, being supervised and not convicted. Okay, gotcha. Now, under the law, Mr. Ward, if you should be convicted and sentenced to prison for these offenses, upon completion of the prison term imposed by the court, the law provides that the adult parole authority may, at their option, choose to put you under what's called post-release control supervision for a period of up to 3 years. So they don't have to, but they can. If they make a decision, the judge has no involvement. If the parole authority decides you should be supervised on your release from prison, that would be for a period of up to 2 years. They would set the conditions and the parole officer would supervise you. If the parole authority found that you had failed to comply with their conditions while under that supervision, they could return you to prison, make you serve an additional period of up to 9 months for any one violation. But there's a cap or limit of cap of whatever prison term you serve for all violations. But if your violation is a new felony, then an additional whatever sentence the judge in the new case imposed upon you, that judge could also sentence you for committing a new felony while under post-release control supervision in this case to an additional period of 1 year or whatever time is left on that 3 years or 2 years of post-release control, whichever is greater. In fact, period that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Right now, I'm not required to sentence you to prison for this offense. I can put you in what's called community control, which means that, and that's the same as probation. So what that means is that instead of going to prison, you'd be put under the supervision of a probation officer for the term set by the court. If during that period of time, the probation department felt that you were not complying, they could file a written notice of that alleging the violations with the court and serve a copy upon you. You would then be entitled to have a hearing, and you would be entitled to be represented by an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control and then sentence you to 24 months in prison and fine you $5,000. Do you understand that?
Yes, sir.
Right now, under the Constitution, under the indictment, count 1, it's alleged that on or about June 25, 2021 in Piney County, Ohio, that you and John E. Richards did knowingly by force, stealth, or deception trespass on the land or premises of Gerald Doug Halkey with the purpose to commit a felony in violation of Section 2911.13b of the Ohio Vice Code. So that's the charge of breaking and entering. Count 2 alleges on or about June 25, 2021 in Piney County, Ohio, that you and John E. Richards did with purpose to deprive the owner Gerald Doug Halkey of his property, knowing and obtain or exert control over said property to wit Milwaukee saws, Milwaukee impact, Milwaukee batteries and chargers, Milwaukee sawzall or blades, Milwaukee metal shear attachments, steel chainsaws, and other miscellaneous items. Without the consent of Gerald Doug Halkey, the owner or person authorized to give consent, said property being valued at equal to or greater than $1,000 or less than $7,500 in violation of Section 2913.0281 of the Ohio Vice Code. So that's the charge of that. And each of those are 53 felonies carrying possible prison terms of 12 months and a fine of up to $2,500. Now, Mr. Ward, do you understand what it is you've been charged with in each of those charges, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
You understand the possible penalties for each offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence of the charges, the evidence of the case, possible legal issues of the case, possible offenses you might try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, on page 2, there's 3 lines that have been printed in bold and underlined, and then also there's some additional sentence written in by ink. So I'll read that portion of the page 2 at this time. Defendant shall enter plead guilty to the indictment. State defense jointly recommend controlled substance abuse treatment. Defendant agrees to cooperate fully against co-defendant. Defendant agrees to make full restitution of amounts to be determined. That's your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, Mr. Orr, the matter of sentence is up to the judge, not the parties. So even though there is a recommendation from both parties that you be given complete control on these charges if you plead guilty, I'm not required to follow that recommendation. So at the time of the sentencing, once I received all the information that's presented, if I determine that that's not the appropriate sentence, then I could sentence you to prison for up to 24 months, and I could also fine you $5,000. You understand that?
Yes, sir.
And from this morning, in the earlier hearing, my understanding restitution has not been yet established, so it would be a matter for the sentencing hearing.
Correct.
All right. Now, and you've consulted with the victim, and he's okay with this disposition
Yes, sir.
in both cases. All right. I think I forgot to ask that earlier. Now, Mr. Orr, do you hold any license or certification from any state governmental agency that regulates any kind of a profession?
No, sir.
Now, you have certain constitutional rights, you must understand, before I can accept the guilty from you in this case. First of all, you have a right to have an attorney, and Mr. Wagner has been appointed to represent you, but that wasn't simply to work the case out, but provide any defense that might be available to you under the law that you would like him to provide. So, if you don't want to do this, if you want to defend against these charges, I should say, then he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Orr, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on your trial. After they are selected, the evidence will be presented, they'll be instructed on the law, and then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree in each case, in each count, as to whether or not the state proved your guilt of that count. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of the jury hearing the evidence, it would be the judge who would hear the evidence. The judge would be the one to apply the law. The judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt on either or both charges. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Orr, you have a right to confront witnesses in open court and cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily at your request, the court issues court orders, no subpoena, that would force those witnesses to come in court to testify on your behalf if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify not be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to comment about it except in one situation. And that is, if there's a jury trial and you don't testify, the judge instructs the jury, and because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of each offense charged by proof beyond reasonable doubt. What that means is that the burden of proof is on you to try to prove that you're not guilty of these offenses. In fact, under the law, you don't have to put on any evidence at all. You may, but but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now, originally you entered a plea of not guilty to these charges, not guilty plea, denied the allegations in each indictment and in each count, denied you committed any crime. That exercised or invoked all the rights that I have described for you today. Now, if you change your plea from not guilty to guilty, that is a complete opposite of the not guilty plea. The guilty plea admits the allegations in each count of the indictment, admits that they're a crime, that you committed that crime in each count. And that plea waives, gives up all of the rights that I've described for you this morning, except the right to have a jury trial, because you always have a right to have a jury trial, no matter what you plead. But with that exception, your plea of guilty would waive, give up your right to have a jury or a court trial. It would waive, give up your right to confront witnesses against you to cross-examine through your attorney. It would waive, give up your right to use the power of the court to compel or force witnesses being court to testify for you, the same as the state. It would waive, give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you're guilty. It would also waive and give up your presumption of innocence, because if you say you're guilty, the state is not required to prove you're guilty. The plea of guilty also waives and gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence or under the certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing after being filed. And finally, a subjection to being sentenced immediately by the court, if that's the court's determination. Now, do you understand all of that?
Yes, sir.
Mr. Ware, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charges or the possible penalties in either count?
No, sir.
You understand?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand?
Yep.
And again, you understand the recommendation of sentencing is not binding on the court.
Yes, sir.
Do you have any questions about the constitutional rights of the claim?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you have that plea here today? Do you have any questions?
Oh, no.
You understand?
Yes, sir.
Anything you'd like to speak to Mr. Wagner about before we go any further?
No, sir.
Have any questions about anything I've explained to you today?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to both counts of the indictment pursuant to the terms of this written agreement that we've just gone over?
Yes, sir.
Then as to the charge which alleges that on or about June 25, 2021 in Highland County, Ohio, that you and John E. Richards did knowingly by force, stealth, or deception trespass on the land or premises of Gerald Doug Howkey with purpose to commit a theft felony in violation of section 2911.13b, the Ohio Revised Code. The charge of breaking and entering a 5th-degree felony, carrying possible prison term 26 to 12 months, and fine of $2,500. How do you plead?
Guilty.
As to count 2, which alleges on or about June 25, 2021 in Highland County, Ohio, you and Johnny Richards did with purpose to deprive the owner of Gerald Doug Howkey of his property, knowing obtain and exert control over said property to it Milwaukee saws, Milwaukee impact, Milwaukee batteries and chargers, Milwaukee sawzalls and blades, Milwaukee metal shear attachments, steel chainsaws, and other miscellaneous items, without the consent of Gerald Doug Howkey, the owner or person authorized to give consent. Said property being valued at equal to or greater than $1,000 or less than $7,500 in violation. Section 2913.02A1, the charge of theft, a 5th-degree felony, carrying possible prison term between 6 and 12 months, and fine of $2,500. How do you plead?
Guilty.
All right, thank you. Be seated. The court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. As to each count, the defendant is found guilty of each of the 2 counts set forth in the indictment as charged. Court will order a pre-sentence investigation under the same bond. Court will set sentencing for February the 17th at 2 o'clock. The Court of Appeals will be here that morning, so we think they'll be done by 11 or so, but in case that comes up, that that's not the case, it may have to be set back. But at this point, we'll set it for 2 p.m. That should allow plenty of time. All right. Is there anything further from counsel?
No, sir.
All right, then you're going to get your assignment notice for your hearing date and go right down to probation to make an appointment for your pre-sentence interview. so they can, meet with you, get information that will lead to the report that's gonna be filed, that I'll use in determining your sentence. All right, thank you.
Thank you.